On behalf of the Canadian Association of Research Libraries, welcome and thank you for joining our webinar, User Rights in the Age of Generative AI. Bienvenue et merci de vous joindre à nous à notre webinaire, Les droits des utilisateurs à l'ère de l'IA générative. My name is Catherine McColgan. I'm the Manager of Administration Programs at CARL. CARL's offices and my home are located on the traditional unceded territory of the Algonquin Anishinaabe people. And I'd invite you to take a few moments to think about the lands in which you're joining us from today. Nous sommes reconnaissants du lien durable qui unit les premiers peuples à cette terre et reconnaissance les injustices historiques auxquelles ils ont été confrontés. Dans nos interactions, nous nous engageons à respecter leurs droits, leur histoire, leur culture et à favoriser la réconciliation et la collaboration. The organizers of this call are committed to providing a welcoming, professionally engaging, and safe experience. Links to the CARL Code of Conduct will be posted in the chat. If you have any questions or concerns about this, please contact Michael Vandenberg, who is on this call, CARL's new executive director, whose contact information will also be added. Please note that today's session will be recorded, as you've heard. And with that, I will hand it over to Michael to say a few words on behalf of CARL.
Thank you, Catherine. Bonjour, je suis ravi de vous accueillir et de me présenter. Je suis Michael Vandenberg, Director General de ABRC. So thank you for joining us this afternoon for this program of the Policy and Advocacy Committee. Today's discussion aligns closely with the committee and CARL's role in shaping informed policy discussions in the federal information policy arena. So at their core, Canadian research libraries work to ensure broad access to knowledge and responsible stewardship of Canada's information assets. And that mission is directly implicated in current debates around copyright and generative AI. The rapid emergence of tools like ChatGPT and other generative AI systems has intensified the debate around copyright status of AI-generated works, use of copyrighted materials to train AI models, and the evolving balance between creators' rights and user rights. And these issues affect research, teaching, and access to knowledge, and are therefore central to CARL's advocacy mandate. This program is hosted by our CARL Visiting Officer for Copyright and Other Public Policy Matters, Stephanie Savage, Scholarly Communications and Copyright Services Librarian at the University of British Columbia. We are grateful for her leadership in convening this conversation. So I will now turn the session over to Stephanie to lead today's program and introduce our speaker. Over to you, Stephanie.
Thanks, Michael. Hello, everyone. As Michael said, I'm going to be moderating today's session, which of course is in celebration of Fair Dealing Week. So as a brief reminder, Fair Dealing Week is an annual celebration recognizing the essential role of fair dealing and user rights in Canada. It offers a moment to reflect on the significance of these rights within academic life and across society, and provides an opportunity to bring our community together to consider how fair dealing continues to evolve and adapt to shifting technological and societal conditions. So this year, CARL is pleased to have Professor Peter Yu joining us to give a talk on user rights in the age of generative AI. Professor Yu is University Distinguished Professor, Regents Professor of Law and Communication, and Director of the Center for Law and Intellectual Property at Texas A&M University. He is a leading expert on international intellectual property and communications law and has written extensively on the interplay of technology and copyright law. In today's talk, Professor Yu will examine the protection of user rights in the age of generative AI, exploring the challenges and uncertainties surrounding such protection. His presentation will interrogate whether the arrival of generative AI has raised new questions about the protection of user rights, and if so, what policy responses should be introduced to address these questions. Our intention is to leave a bit of time for questions at the end, so I'll encourage you all to leave yours either in the chat or the Q&A as we go, and I'll be happy to read them aloud during the question period. So thank you again for being here to celebrate Fair Dealing Week, and please join me in welcoming Professor Yu as we begin today's session. Peter, on to you.
Thank you, Stephanie. It's a pleasure to be here, especially for the Fair Dealing Week. It's also very exciting to see so many of you out there from the list of participants. So let me add a slide right here. So the topic, as Stephanie mentioned, is user rights in the age of generative AI. And I was fortunate enough to be in Toronto for a conference celebrating the 20th anniversary on CCH. And so it's a pleasure to be able to share some of my thoughts here that also benefits from that conference. So I've been a long time observer of what's going on in Canada, and it's always a pleasure to see the new developments going on the other side of the border. And one of the things that caught my attention several years ago is the UGC exception you guys adopted, and I actually proposed that for the copyright reform in Hong Kong. So for those of you who are in Canada, you see that what's going on in Canada also affects other places. So I think a good starting point for us will be to talk about copyright exception for the use of copyrighted works to train AI models. So Professor Masek and I wrote an article recently on the globalization of copyright exception for AI training. And for that article, we hold on. For the article, we look at the different countries that have adopted exceptions for AI training or computational data analysis or text and data mining or something similar. And so it does not matter whether the country has author's right or copyright, whether they're in the civil law tradition or the common law tradition, they're developed or developing countries, or the type of economic model they have within the country. And so we separate the countries into three groups. And the first group is basically fair use because we are writing that for the US journal. So we start off with fair use. And US is obviously the textbook example of what's going on there. Israel also adopted an opinion supporting use of copyright works for machine learning. And so that's available online and you can get it from there. But US and Israel are not the only countries. There are many other countries that have adopted fair use or fair use-like regime in the copyright system. And so these are the different countries right there. What is unclear for us is how we should classify Canada. Matt and I will probably put it here in light of user rights. So even though there's no fair use exception based on different factors, I think the user rights is broad enough to be classified within the Group 1 countries. The Group 2 countries are basically have designated limitation exception. And so with respect to text and data mining, I think Japan, UK, EU, Singapore are those countries that usually come to mind. And what's actually quite interesting is that if you see on the slide right here, Japan is the first country before we have UK, EU, and now Singapore. So let's go to Japan. So Article 34 is the provision that's been adopted in Japan that will allow people to have to use the copyrighted works without personal enjoyment of the thoughts and sentiments expressed in the work. So what can they do? They can do technology testing, they can use in data analysis, or they can do computer data processing. This is actually a very broad exception that you can get as long as you're not taking personal enjoyment of the thoughts and sentiments expressed in the copyrighted work. The yellow color that's on the slide are actually not the specific conditions. Those are just examples. You can add other conditions with respect to this particular provision. I think there is included right there, right below the orange color, about the fact that you cannot prejudice the interests of the copyright owner in light of nature and purpose of the work or circumstances of its exploitation. So that's actually taken from the three-step test that you got in the TRIPS agreement as well as the WIPO Copyright Treaty. So that is somewhat tricky in terms of interpretation, but at the same time, this is one of the broadest exceptions you get in the world at the moment. So as I mentioned earlier on, Japan is the first country that's adopted this type of exception. And I think for those of you who are interested in comparative law, this is actually quite interesting because most of the time when we get an IP provision, whether it's copyright, whether it's patent, they usually come from the West and then go to Asia. And this one actually happens in Asia first, and then go to UK and then the EU. Singapore, during the pandemic, also adopted a provision for computational data analysis. Now, this one is more narrow than what you get in the one in Japan, where the copy has to be made for specifically for computational data analysis, cannot be for other purpose. You can supply the copy to another person, but only for verifying the results or collaborative research, right? You also need to have a lawful copy. So there's a lot of requirement that's included in Section 244 of the Singapore Copyright Act that was not available in the Japanese copyright provision. And so this one is more narrow, but this one is also the latest. And that was adopted in 2021, so around time when we have the COVID-19 pandemic. Singapore is interesting because Singapore is also a Category 1 country where Singapore actually has fair use. So initially, fair use is basically framed in the form of fair dealing, and that was adopted right after the US and Singapore signed the free trade agreement. But now the fair use provision upon the amendment is basically the same as what we have in the US. So there are 4 different factors. If you look at them, they're basically the same as what we have. So Singapore is interesting both because it fits within Group 1 and Group 2, but it also is interesting because it has fair use as well as the TDM exception. And so if the TDM exception cannot cover the provision, we can rely on fair use and vice versa. And so one interesting scenario is that Singapore can actually have broader protection on fair use and fair dealing than the United States. So if assuming all the case law in Singapore about the interpretation of Section 190 on fair use is the same as the US. If anything is not covered by the provision on fair use, they can always rely on the special provision for computational data analysis. So they get one additional provision that they can use in light of AI development. So a third group of country we got is basically the countries that are very eager to develop AI, but at the same time, it has not taken any major copyright reform in the direction of text and data mining, computational data analysis, or AI training. So China is a very good example. So during the pandemic, China also amended the copyright law. So it's a complete overhaul within China. And so Article 24 used to be Article 22 is the provision for limitation exception within the copyright system. And during the amendment, China added clause 13, which says that other circumstances as provided by laws and administrative regulations. So when you have other circumstances, that shows that the system is broader than just the 12 stipulated limitation exceptions that you currently have under Article 24. But at the same time, this one is not an open system like the copyright system in the United States. What it says is that other circumstances as provided by laws and administrative regulations. That means you need to have the law and administrative regulation before you can fit within the other circumstances. So it's not a catch-all under any conditions, but it's a catch-all that can be stipulated by future laws and administrative regulations. So this will be closer to the open system, but it's still closed system in light of the fact that they have to have provided laws and administrative regulations to have other circumstances. UAE is also another example where it has been very active in investing in AI development. The Falcon series for AI model is a very good example of what UAE has been trying to do. But UAE is actually interesting in light of the fact that there has been no copyright reform even now. And so they have been aggressively pushing for investment and development of AI, and yet they haven't reformed the copyright law yet. And so that will give you some ideas as to what's going on in different parts of the world. We have 3 groups of countries that are taking very different approaches. So on the slide here, as well as the next one, we include 2 tables that's in the article. So for those of you who are interested, I will not be able to spend that much time talking about it. But the first table talk about the affordances for machine learning and AI training. We look at basically Group 1 and Group 2 country. We were unable to do it for Group 3 because there's a lot of uncertainty. We also do not have as much information as we would like. And table 2 talk about the implications for rights holders and AI developers. And so that's included right here. The article is available online. So you can get it from either the Emory Law Journal or SSRN or other places. So it's available there, and you can get the two tables. So what we concluded in the article is that there's no consensus at the international level, but we see an emerging equilibrium for copyright limitation exceptions for AI training. And that's actually quite promising for those of us who are very supportive of user rights, fair use, fair dealing, etc. And so then the question is why? There are a number of reasons, and we pin down on three different reasons. The first one is the idea expression dichotomy is basically the grand norm of international intellectual property system. So with respect to copyright, we got it within the TRIPS agreement, for example. We have this in statute, we have in case law, and what the AI models have been using is actually what we consider as non-expressive use of the copyrighted work. Right. So if you go back to what I said early on about the Japanese copyright provision, they focus on the non-personal enjoyment of the copyrighted work. And so as long as you're not using the thoughts and sentiments of the expressed in the copyrighted work, then you'll be allowed under the copyright system in Japan. And so this is one of the reasons, and idea expression dichotomy is basically the position taken by virtually all the member states of the Berne Convention as well as other countries. The second reason we offer is a lot of countries are very eager to get into the global AI race, and they look at what has been done in the US, in the EU, in other places, and they can see that there are a lot of benefits of having more limitation exceptions for AI training. So we can see a lot of countries basically agree on the same thing. If they want to develop AI and facilitate more adoption, they need to make sure that the copyright system is actually tailored to that type of national goals. And so with respect to AI development, we see a lot of countries basically embracing that approach. And the third reason we offer is what we call race to the middle, and that's also been advocated by other colleagues in other areas. The idea is that we always talk about the race to the top and race to the bottom, but at the same time, we see a lot of countries, we see a lot of governments, we see a lot of cities trying to go for what we call the race to the middle. And fair use and fair dealing is actually a very good example because a lot of the reform we have seen so far in the other countries trying to propose or adopt fair use, they're going for a hybrid model. They want to keep a portion of the status quo, but at the same time, they also want to introduce new elements, including the multi-factor balancing that's adopted in the fair use provision in the US. So there are a number of uncertainties that may upset the equilibrium we talk about. And I want to share with you three different uncertainties, and then we'll be able to open up for questions. So the first one is what's going on in the US. We have a lot of copyright lawsuits in the US. So for those of you who are observant, you can see that this is actually not all the lawsuits right here in the US. So listed on this slide is actually when I first started writing that article. And this is the different lawsuits that have been filed. And by the time I presented this presentation at the CCH conference, we already got more than 40 lawsuits. So the slide is this one. And I just took the latest one from the website, ChatGPT is Eating the World, that is put together by Edward Lee from Santa Clara. Now we have more than 80 lawsuits, right? So US loves lawsuit, and you end up with a lot of different lawsuits with respect to the use of copyrighted works for AI training. So within US case law, we can see a lot of cases that are very supportive of AI training. So iParadigm is a good example, Google Books, HighTrust, those are all examples. So when we were writing an article, we believe that the court will actually take the same position. And now we do have two cases that are widely notable in the AI area. One is the one BuzzFeed Anthropic, the other is Carteret and Matter. And so those are important decisions that have just come out, and we are looking forward to other decisions that are coming out with the ongoing litigation. So in the Buzz case, what they talk about is that use of copyright works to train AI models is exceedingly transformative, right? So that is actually similar to our projection based on the case law we have. The problem with respect to Buzz is that Anthropic has relied on what we call the shadow libraries. And so the shadow libraries included a lot of copyrighted works that are not licensed. for distribution. And so that becomes a problem in the Anthropic case. And in the second case, Carteret is actually done in the same district court in California, but from a different judge. And it says that, well, we cannot just determine downloading from those shared library will be constitute piracy, because that begs the question as to how we determine fair use, right? And Carteret continues to talk about the fact that use of copyrighted works for training purposes is highly transformative. But that case introduced the idea about copyright dilution, which is actually somewhat troubling for those of us who are copyright purists, because normally we talk about dilution in trademark law, but we don't do so in copyright law. But dilution is actually something that's being incorporated in the pre-published version of the Part 3 report coming from the Copyright Office on copyright and artificial intelligence. And so dilution actually is included in the section. And so for those of you who are interested, you can see that that is in the mindset of both the judges as well as the Copyright Office. So we can see that from the cases, we talk about there's convergence substance, but there's variation in form, and that's why this area is still somewhat unsettled with respect to what's going on in the US. But we do know that there are a number of options based on those cases, based on statutes, and I think that's actually very exciting for those of us who are celebrating fair use and fair dealing this week. The second uncertainty, or second set of uncertainties we got comes from the EU. So the EU adopted the AI Act, and I think that's on the radar of a lot of you guys. Two things I want to highlight here. One is Recital 106, which is not operative, but it shows the intent of the drafters of the AI Act. And I'll talk a little bit about that later on. And then the other one is Article 53, which includes the different obligation. And so that I mentioned remuneration here because it's relevant, but there's also a transparency provision about disclosure that's in Article 53D. So Recital 106 says that any provider placing a general purpose AI model, which is basically a foundation model, on the EU market should comply with this obligation under the EU AI Act, regardless of jurisdiction in which the copyright relevant acts underpinning the training of those GPAI models take place. What does that mean? That means if you are training the model elsewhere, when you bring the model into EU for operation, then the EU AI Act will be applicable to the model. And this is actually quite problematic for a lot of us who think about it from the choice of law perspective or conflict of law perspective. For those of you guys who are from European tradition, is private international law, right? So when you think about the fact that if it is basically not personal enjoyment of the copyrighted work for AI training in Japan, that is legal. And so when you have something that's lawfully trained and you bring into EU, why all of a sudden it becomes illegal? So from the copyright standpoint, based on choice of law, it's going to be complicated. From the product liability standpoint, to the extent that you believe that there's a dangerous product being imported into EU, I think that actually makes more sense, right? So the more you look at the EU AI Act, the more you think that is basically a product safety regulation, then it makes more sense than if you look at it from the standpoint of copyright with respect to Article 53, because there are serious choice of law questions that will come out, especially when the foundation model has been lawfully trained aboard. So Article 53 talks about the fact that you need to comply with the EU law on copyright, and that would include the Digital Single Market Directive. And so that was adopted in 2019 before the pandemic. And within the directive, it says that the copyright holder can actually decide whether they want to reserve the rights to allow people to use the copyrighted works for text and data mining. Now, it's important to remember that the DSM directive includes two different provisions. The first one is for the purposes of scientific research, and that's allowed. You don't need to have permission, and that's why we got a Lion case that's coming out from Hamburg, where the court basically just go over the German version of Article 3, the German version implementing Article 3 of the DSM directive. And Article 4 is the one we are talking about, because we are not talking about scientific research. We are talking about commercial AI developers that are actually providing services, sometimes on a subscription basis. And so Article 3 will not be applicable in this case. So the big question there will be about the opt-out mechanism that has garner a lot of attention from scholars, policymakers, as well as other people interested in copyright. And there's also a related debate with respect to equitable remuneration. So the default issue with respect to equitable remuneration is that we have to think about whether we want to actually apply it on the input side with respect to the training process or on the output side. Now, on the input side, it's going to be quite problematic because it's going to affect AI development. They're also concerned that for a lot of the licensing deals that we have developed, we will basically allow uh, the mainstream content to be used for training purposes, though that makes it much more difficult with respect to other type of content that's not within mainstream or developed by individuals, right? So there's a concern that the training data will actually skew in a certain direction, and that will make the training not as good as it can be. They will also allow the output to be much less diverse, and so that's quite problematic as well. And they're also concerned about how a lot of the big companies, they have the resources. Some of them, like Matter, already have the licensing terms that will allow them to use the content provided by the users, and so that type of system will actually favor the big companies. So that debate is actually similar to, for example, Article 17 of the DSM directive about online filtering, where the bigger ISPs will be in a better position to provide the type of filtering mechanism than the smaller ISPs. So we see the same issue here with respect to AI development. With respect to the output end, we also run into an issue because not everybody can actually draw, not everybody can paint, right? So that becomes quite problematic. And so to the extent we want to have a lot of scholars, whether it's John Fisk, whether it's Terry Fisher, they were talking about the semiotic democracy, and I think that will be much more difficult for us to develop that type of arrangement. So the big question within the generative AI space is, do we want to allow people who can paint to paint? Within fans art community is actually quite divided in terms of whether they want to allow people to be able to do that. And so that's quite interesting as well, because there's a tendency for us to say, well, the fan artists will probably be very supportive, but at the same time, AI training is actually somewhat controversial, even within the community. So on both sides, it's become difficult, and so we are still looking at the different proposals that are available, but either way, you run into some concerns and problems. And Katrina Gaddis, who is now teaching at Ohio State University, actually has a very interesting article about engineering semiotic democracy, and she focused on the output end with respect to the opt-out arrangement. And I recommended this article not just because of that, but also because she actually used the proposal that is inspired by the Section 2921 of the Canadian Copyright Act. So the last thing I want to share with you is about the increasing push for content moderation in generative AI. And so if the copyright holders cannot get the AI developers to do it on the inputting end or the outputting end, they will push for more content moderation. So a good example would be filtering. So there are different ways they can actually do content moderation, and not just filtering, as I mentioned. They can do reinforcement learning, supervised fine-tuning, prompt blocking, output filters, machine learning. So I did this slide a few months ago, but when you think about things like prompt blocking, that's already changing very quickly. So I suspect in a year or two, some of the different options will change as well in light of the changing technology. But the default issue here is that sometimes you need to use an entire or a substantial portion of the copyrighted work in order for you to make a point. Parody is a very good example. Right here, you include both the Mickey Mouse here, which is protected by copyright under Disney, and then you also can have basically the American Gothic painting in the back, so you can see it right here, and that's been used as well. Right, so that's a very good example how you actually need to use copyrighted work sometimes in order for you to make a point, and AI can help those people who cannot paint to actually come up with the graphic they want to have. There's another suggestion about what if we rely on technology to actually determine whether you can use the work or not. And this is also very controversial as well. And the late Dan Berger says no. He has a very good article called Algorithmic Fair Use, saying that there are many problems why we do not want to have use automated system or algorithm to determine what is fair use or fair dealing. But at the same time, we also need to take note of the fact that AI system can provide very important benefit, and that's in terms of scalability, right? So AI is scalable. You cannot use human decision makers to determine all those questions, and you just be too slow and too time consuming. And so AI can actually do that much better. So I think a good question for us to ask is, can algorithm promote fair use, right? There are pros and cons, as with most other things in the corporate area, and I think we need to do a cost benefit analysis. We need to make some assessment. I think the difficult issue for a lot of people is that for those of us who are lawyers, we are trained to go for precision. And I suspect that will be the case for a lot of the librarians here. They have been handling issues and fair use issues quite a bit, so they go for precision. What we have in the AI system or any automated system is they go for high probability. We can debate as to whether 95% probability is good enough, but at the same time, it's not precision. So I think that will be quite difficult, I think, for a lot of people to accept if we're going to move to an automated model to determine who can actually do it in the generative AI space. So there are still a lot of questions, but I'm actually willing to take more questions, and so I'll stop here. Thank you very much.